The next matter to come before the court is State of Ohio versus Kimbrough. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve any time, I'm keeping track of the clock here this morning. So let me know when you get started and I can keep you informed about how much time has passed and is remaining. Please do not use the name of any victims or minors in this case. We have read the briefs and we are ready to proceed when you are.
Good morning, Your Honors. On behalf of Mr. Eddie Kimbrough, Giovanna Bremke, I would reserve my full time for rebuttal. I presented to the court, as you're aware, 3 assignments of error, manifest weight, sufficiency of the evidence, and the first assignment of error being the court's failure to declare a mistrial after newly discovered evidence came forward mid-trial of a surprise witness. Mr. Kimbrough was charged with 2 counts, 1 kidnapping, 1 rape. The case proceeded to a jury trial and he was convicted of the rape and not guilty of the kidnapping and sentenced to 8 years. I'll refer to the victim as TS in this case. And the facts, they are important for the later 2 assignments of error. And there's a difference in facts here. So my client did testify. He testified that they had that him and Mr. Kimbrough and TS had hung out daily, that they were both, unfortunately, addicted to crack cocaine, and that my client financed the transactions, but that TS had made arrangements for the transactions. He testified that they had regular consensual sexual relations. And on the night in question, there was a dispute over the crack cocaine, that they had run out of money and that there was an altercation ensued. My client admitted to choking and hitting TS, although there wasn't necessarily charges related to that. After that fight, he testified that he had gotten her an ice pack or ice, that they laid on the bed together, and then that they proceeded to have consensual sex. And after that, she had rolled cigarettes, and they laid respectively on their sides of the bed. That, again, they had a long-standing relationship, and went to bed. In the morning, she had gone to the police. So her version varies in that she testified that they had attempted to have consensual sex months prior, but that due to his genitalia, it was incompatible with her body, and that she contends that the sex on this night was not consensual. Significantly, for my first assignment of error, she also testified that she could not be intimate with others, and that she had a hard time even hugging her fellow AA members. Again, that's significant for the first assignment of error. What you'll see is that it's a discovery issue, in that at some point during the trial, the state rested and the court took a brief recess at that time. And again, this is sort of played out in transcript, the page 200, around 206, 207. There was a witness in the gallery of the courtroom who came forward and talked to Mr. Kimbrough's attorney and said, hey, why didn't you ask her about the fact, TS, about the fact that she has a career as a prostitute and that she continues to be intimate with men, because she did testify that she cannot be intimate with men as a result of this incident. And the attorney says, I wasn't aware of that. There was discussion on the record, and the defense attorney, Mr. Kimbrough's attorney, asked if he could question Mr. Perry or have a continuance in order to explore the surprise witness. The court, and what that was, what it entailed, and what the record will show, transcript page 207, is that this gentleman had sexually explicit conversations, nude photos, offers for sexual services through his phone from TS, after this alleged incident. And the court refused to declare a mistrial, refused to allow defense counsel to have more time to explore this witness and this newly discovered evidence.
Excuse me, but was there a proffer of that evidence into the record there?
There wasn't a proffer of the messages, Your Honor. I'll admit that, but there was, again, a detailed description of what those items were, and that's, again, around page 206, 207 of the transcripts.
And let me get to the request for the continuance. How long of a continuance was requested by defense counsel?
I don't want to state something out of turn. I don't believe that there was I don't believe that he had asked for a set amount of time. He just asked for additional time to be able to explore these items.
And was there ever a in-camera inspection of the evidence?
Not to my knowledge. I don't believe that's reflected in the record.
Okay, thank you.
And counsel, you have reached about 30 seconds to 45 seconds into your rebuttal time.
Okay, I am going to briefly, even if I go into my rebuttal time, touch on the other two assignments of error. The second being sufficiency of the evidence. And again, what's significant here is that the force element of things, he was found not guilty of the kidnapping, and he admits that there was an argument, physical fight that ensued over the crack cocaine. He admits to that, and the detective and state nurse testified that this injury could have been consistent with that altercation as opposed to the rape. Additionally, the manifest weight centers around the credibility of TS, and in that she didn't admit to some incredible things, including the addiction that she suffers from, failure to admit that they had continuously had consensual sex prior to this incident. And those things, again, given the manifest weight of the evidence, the two witnesses that are testifying are, there are other witnesses, detective and a sane nurse, but essentially my client and TS were the two that were there, and that I would submit to you that my client, given the fact that he admitted to these physical altercations, is more credible. I will reserve the rest of my time.
Thank you, counsel. The state may proceed.
Good morning, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state of Ohio. I'd like to begin by addressing the sufficiency argument briefly. And as the appellant indicated, there are two versions of events in this appeal. Eddie Kimbrough admits to getting into a physical altercation with the victim on the night at issue. He also admits that this fight became violent, and during the altercation, he choked and hit the victim. Despite those concessions, he asked the jury, and now asks this court, to believe that although he admittedly beat and choked the victim for a period of time, they then got into bed and had consensual sex. The victim testified that she and Kimbrough got into a physical altercation wherein she pled for her life and begged Kimbrough to stop beating her. In stark contrast to Kimbrough's version of events, the victim testified that Kimbrough then raped her while he continued to threaten her life. Against this backdrop, Kimbrough claims that his conviction for rape was not supported by legally sufficient evidence because the state did not prove the element of force. Despite being battered and bruised, as evidenced by photographs and the testimony of the sane nurse and a Lorain police detective, Kimbrough maintains that the victim's injuries are just as easily the result of the physical altercation to which he admits, and that the state failed to prove the element of force. The rape statute requires that only minimal force or threat of force be used in the commission of a rape. Moreover, the force need not be overt and physically brutal, but can be subtle and psychological. As long as the rape victim's will is overcome by fear or duress, the forcible element of rape can be established. Here, the victim's testimony, if believed and taken in the light most favorable to the state, as this court must do on a sufficiency review, demonstrates that she expressed her lack of consent and that Kimbrough used both physical and psychological force to make her submit to the sexual conduct. Yet, in arguing that the sexual encounter was consensual, Kimbrough completely ignores the victim's testimony, which was also corroborated in the same report. The victim testified that during the physical altercation, she was pleading with Kimbrough for her life and begging him to stop beating her. The victim testified that during the rape, Kimbrough told her he was having sex with her no matter what. The victim testified that she told Kimbrough, no, don't, and stop, but he strangled her and held her down as he had done throughout the physical altercation. And he told her if she did not have sex with him, he was going to kill her. Force and threat of force can be inferred from the circumstances surrounding the sexual conduct. And here the state would submit that not only was there sufficient evidence of physical force, but also there was evidence that the victim's will was overcome by fear that if she did not submit to the sexual conduct, that she would be killed. Here, Kimbrough's sufficiency argument fails and should be overruled. As to the evidentiary issues that Kimbrough raises, the state would submit that the number of issues that Kimbrough raises have not been preserved for review on appeal. Kimbrough asserts that the trial court erred in failing to declare a mistrial after the witness came forward with the surprise evidence. But the record is clear that while Kimbrough objected to the trial court's ruling excluding the evidence he sought to introduce, he at no point moved for a mistrial. As a result, Kimbrough has forfeited all but plain error on appeal, but has failed to argue plain error on appeal. And this court has noted a number of times that when a party fails to argue plain error on appeal, it will not sua sponte fashion a plain error argument on appeal and address it for that party. As you noted, Judge Teodosio asked, the recess that Kimbrough asked for was merely a brief recess to research the issue and look for some authority that he could then present to the trial court on the issue. He did not request a continuance of the matter. And we would submit that because he did not ask for a continuance of the matter, he has failed to preserve that issue for appeal as well. And as the trial court clearly excluded the evidence, and as Kimbrough now concedes, he did not make a proffer of that evidence, and therefore it is not a part of the record for appellate review. And the court cannot rely on Kimbrough's mere contentions concerning what the text message or photo evidence depicted. Rather, in order to preserve the issue or any error for his appeal, he should have proffered the exhibits and/or testimony. And because this court has no proposed evidence to review, it must presume the regularity of proceedings.
One of the reasons I asked about an in-camera hearing, I should say, was because I was curious as to Ohio's rape shield statute and how that plays into this issue.
Right, and I think that this evidence would have been, I know that the defense counsel said that he was not trying to circumvent the rape shield statute by attempting to introduce this evidence, but he was merely trying to use it to impeach the credibility of TS. But I think this evidence would have fallen within the rape shield statute under 2907.
If that's the case, should the court have had a in-camera hearing, or was that the responsibility of Mr. Kimbrough to request that in-camera hearing?
That would have been the defendant's responsibility to request it, and if again, he did not object to that. If the court would have failed to hold that hearing, there was no objection by the defendant.
All right, thank you.
And finally, as to the manifest weight argument, the state would submit that after this court reviews the entire record, weighs the evidence, and makes all reasonable inferences, it will be evident that Kimbrough's conviction does not require reversal. Here, Kimbrough essentially attacks the credibility of the victim and maintains that his testimony was more credible, believable, and honest. However, several of the challenges Kimbrough makes to the victim's credibility are simply unfounded. First, and contrary to Kimbrough's claim, the victim did admit that she had sex with Kimbrough on several occasions prior to the incident at issue. And as this court has noted a number of times, a jury is free to believe all, part, or none of a witness's testimony. The credibility of witnesses and the review of their testimony is for the jury, and a reviewing court must give deference to the judgment of the jury. And here, the Kimbrough and the victim did give different versions of the events, but the victim's version of events was corroborated by her SANE report and narrative, photographs of her injuries, and the testimony of those who interacted with her immediately following the incident. Here, the state would submit that it cannot be said that the jury clearly lost its way in convicting Kimbrough, or that his conviction should be reversed. For all those reasons, the state would ask that Kimbrough's 3 assignments of error be overruled and that this court affirm his conviction and sentence.
Thank you, counsel.
Thank you.
Ms. Bremke, you have just over 3 minutes remaining.
Thank you, Your Honor. To speak on the in-court in-camera hearing, I believe the paramount case is State v. Boggs on that issue, the rape shield exceptions. The defense counsel in this case makes it clear that he's not trying to circumvent the rape shield protections that under Ohio law. The whole, I guess my argument to all of this about proffering the evidence, having an in-camera interview, being able to assert the State versus Boggs elements and exceptions, there wasn't even a brief recess, or there wasn't enough time for defense counsel to be able to do that. And that's, again, part of the assignment of error, that there should have been this time to allow for defense counsel to research these items. It's again, the middle of trial, there's a gallery witness that comes forward, and it's appropriate to allow defense counsel to research these matters, to be prepared to have a Boggs hearing, in-camera hearing if necessary, and again, this is certainly an important and a serious matter. It's appropriate to have that brief recess to allow, brief or continued recess to allow for the counsel to research these items and to be able to proffer them into evidence. I think that what the record reflects is that defense counsel was viewing them on a phone, obviously wasn't prepared to have them printed and presented as a proffer, and there wasn't that time afforded to be able to do that. So again, we would ask that you reverse on these assignments of error. Thank you, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to the parties of this appeal, as well as it will be posted on the Ohio Supreme Court website. We are adjourned for